Welcome to Sakshi TV's special immigration talk show. I'm your host Shivani Raj. For today's show, we have Mr. Chand Parvathaneni from SIM Parvathaneni and Brown. Please note that this show is only for legal advisors, and if you need any specific legal advice, you can definitely contact the attorney directly. Mr. Chand needs no introduction, but if you need consultation, please log on to spvlawfirm.com site for contact information. If you need any specific legal advice, you can definitely contact the attorney directly. Without any further delay, let us welcome Chand Parvathaneni Garu onto our show. Parvathaneni Garu, welcome back to India. I hope you're doing well.
Hello, Shivani, and hello, all Sakshi TV viewers. Thank you so much for joining in today. And I would be happy to discuss a couple more immigration issues and what's going on in US on the immigration and H-1Bs and all the non-immigrant visas and issues associated with visa issuance.
Yes. So, Mr. Parvathaneni Garu, today we have a vast topic that we're supposed to cover. But before quickly, can you let us know any recent immigration or USCIS updates?
Sure. So I think the big update that we just heard, which is really going to benefit a lot of people from India, is the stateside issuance of H-1B visas. So what that means is, for getting the H-1B visa, people don't have to travel to India or travel to other countries down the line. So they're making some policy changes. And what exactly is happening is, this is going to be a pilot project. So this is going to be a pilot. And what that means is it is not full blown. And it is going to be a start. And for a start, they're going to accept 20,000 applications. So 20,000 applications. So people will be able to get a visa within US. So without even traveling to India, people will be able to get a H-1B visa within US. And again, what this means and what this is likely going to impact is a lot of people can plan their vacations in India without having to worry about the visas. And the exact process is not out yet, but Department of State, they indicated that this is going to start very soon in December 2023. And the initial project, the initial pilot, it is going to let 20,000 people. And it is going to be renewals. So not the first time visas, but the renewals of the visas. So it is going to target those folks. And 20,000 of those folks can apply to get a visa within US, even without traveling out to the consulate or the embassy. And this happened 20 years back. So again, after 20 years, they're bringing this old process back. And because they want to see how it works, it is going to be a pilot project. And based on it, eventually we expect that to be expanded to other classes. So not just renewals, but other classes, and it will be opened up for more people down the line. So this is a good start. And this is again happening after 20 years. Before 20 years, this was available, this kind of a visa issuance within US. And again, it's going to come back. And it is definitely going to benefit a lot of people because they don't have to worry about getting a visa back home at the consulates.
Yes, great. Mr. Parvathaneni, can you please give us an overview of the application process for the employment-based petitions? And also, what are some crucial steps involved in filing for an employment-based petition?
Sure. So the process for filing any petition, immigrant or non-immigrant. So the way the process currently works is there is a body called USCIS, United States Citizenship and Immigration Services. So that is the government agency that is tasked with processing these applications, these petitions. And in the US immigration world, they divided these petitions in employment-based world into two classes. One, the immigrant petitions. And what that means is immigrant petitions refer to the green card petitions. So anytime somebody is applying, a company is applying for an employment-based green card, they come under the employment-based immigrant petitions. And then they have this other class for employment. This is called the non-immigrant class. So the non-immigrant petitions, they refer to visas like H-1B, L-1, P, O, etc. Because these are employment-based petitions, but they are temporary. They're not permanent in kind. They're just for a specific period. For example, H-1B is given only for 3 years each time. So these kind of temporary petitions come under the non-immigrant visa. So they're not immigrating to US. It is a temporary non-immigrant visa. So in employment-based world, two things happen. Either immigrant visa, where somebody is applying for a green card, the company is applying for a green card petition, or they're applying for a temporary work permit, which is something like a H-1B. So to apply for these kind of petitions, one has to go through this government agency called USCIS. And the process starts off with filing a specific type of a petition for their purpose with USCIS. And that has to be accompanied with a fee. So every kind of a petition has a fee. H-1B, for example, the fee varies anywhere between 1,710 to almost 6,460, depending on what kind of a company is filing for a H-1B visa. And similarly, if a company wants to file for a green card I-140 petition, they have to pay $700. So every petition based on its class has a fee. So the company which is filing the petition for employment, they go to the USCIS, the government agency, they pay the appropriate fee, they submit the appropriate petition. So there are petitions available in the USCIS website. They have to get the right petition, fill it up, submit the fee, and also submit all the evidence. So there is mandatory evidence that needs to be submitted with every class of petition they're filing. And this gets submitted to USCIS. And USCIS is the body that makes sure the right fee is paid, the right documents are verified, and then they will eventually either approve the case or deny the case or ask for more evidence.
Yes. Mr. Parvathaneni, let's talk a little bit about the eligibility criteria. So what are the eligibility criteria for people who are applying for an employment-based, immigration? And also, do they have to have a specific degree or a specific, qualifications or requirements that they have to have for you to file an employment-based petition?
So again, in the employment-based world, so the immigrant petitions are one kind, and in employment-based immigrant petitions, there are 5 categories: EB1, EB2, EB3, EB4, and EB5. So depending on the class, each has a particular requirement for the qualifications of the employee, requirement for the qualifications of the employer, because the employer also has to meet certain criteria, and employee has to meet certain criteria based on what that category we are applying under. So there are 5 categories for employment-based immigration, which basically means green cards. And then on the non-immigrant side, you have various visas. You have, for example, H1. So for H1, the main requirement is the employee should always have a bachelor's degree in a relevant field. Either have a bachelor's degree in a relevant field or have enough experience that is equivalent to a bachelor's degree, for example. And there is another non-immigrant visa, for example, that is widely used by Indians, L1. So L1 has a certain requirement. L1, the main requirement is somebody has to work in the foreign office, for example, the India office, and they're getting transferred to the same company or an affiliate company's US office. So there is a certain requirement. Somebody has to work for at least 1 year in the foreign offshore office. And they also have to meet certain criteria. And for example, O visa. O visa is used for extraordinary ability. And for example, if somebody is a chef in a 5-star hotel in India, is a big chef, is very popular. And if he wants to come and work in a restaurant as a chef in US, as a specialty chef, O visa is a valid visa, for example. So every visa pretty much has a requirement, because the goal in employment-based petitions is the company is requiring a foreign national to come and work in the United States. So the company is the one that is petitioning. So company will have a certain requirement. The company has to be a legitimate company. It should be able to pay the employee, should have the bona fide work in that classification. And similarly, the employee has to be qualified. So together, it's basically the employer meeting the requirements, employee meeting the requirements of that specific class of visa, and that gets submitted to USCIS.
Great. Mr. Parvathaneni, let's talk about the documentation process. So what kind of documents are typically required when you're filing for an employment-based applications? And also, can you explain in detail about the filing process and the paperwork that has to be done in the USCIS?
Sure. So So once the company decides they want some foreign national to work for them, they have to figure out the right form. For example, for H1B. So for H1B visa, for example, the form that needs to be filed is there's a form called I-129. And I-129 will have certain supplements. So for H1B, there are certain supplements. So those will have to be filled up properly. And for example, for a H1B visa, the visa classification also requires a DOL document called an LCA. So they have to make sure they have the LCA. And the company has to also prove that the company is legitimate. They have to prove and show their documents. They also require the employee's documents, for example. So the employee in this case will require the mark sheets, the educational documents, the degree documents. They also require their passports, for example. So depending on the class, they have to make sure they have all those right documents. And typically it is always some documents about the employer, depending on the class. And again, if it's a green card based employment petition, immigrant visa petition, for example, they have to show the tax returns. For EB2, EB3 filings, it's always pretty much mandatory. So depending on the class, so the employer has to provide certain documents. Same thing with the employee. And for an employee, typically it's always their qualifications, the documents representing their qualifications. So their degree documents, mark sheets are most of the time mandatory. And passport pretty much for every petition, it's mandatory. So together, one has to look and see which class they're applying under, look at the requirements and make sure those entire set of documents, both from the company's perspective and both from the employee's perspective, are provided to USCIS.
Yes. And also, let's talk about the processing time, Mr. Parvathaneni. What is the average time that, the people who are applying for an employment-based petition expect? And also, are there any factors that, that the person who is filing for the employment-based petition that can impact their processing time?
So the processing times, depending on the class, again, they vary a lot. Some cases get approved very quickly, less than a month. Some cases take 5-6 months. Some cases take more than a year. We have seen a couple of cases where they're taking more than a year. So again, a lot depends on what kind of employment-based petition is getting filed with USCIS. In general, if it is a H1B case, we typically see anywhere between 1 month to 6 months, most of the cases, in regular process. But then again, some cases have premium processing. For example, a H1B case, somebody can pay $2,500 and get an answer in 2 weeks, in 15 days. And again, if it's an immigrant visa petition like an EB2 or EB3, I-140, again, the time period, it varies anywhere between 1 to a couple of months, 1 month to a couple of months. That being said, the first thing a lot of people will see, a lot of employers will see is premium processing available? Because a lot of these cases are time sensitive, because the employer requires the employee to work immediately, or the employee needs to get an approval immediately because they have to travel out of the country, go for visa stamping and so on. So the good thing is a lot of employment-based cases, even though the regular processing time takes a couple of months, a lot of them do have premium processing. Premium processing is optional. Somebody has to pay $2,500 additional fee and get it done. But the good thing is USCIS will process the case quickly if premium processing is opted. And again, if for that particular class of the petition, if the timeline is not a problem, most of the time what happens is the companies do it in regular processing. And if they have a need to upgrade it to premium down the line because there is an emergency, they'll upgrade it. If not, they'll just let it go in regular process. But most of the cases, if it is just the petition, one can expect a couple of months before it is processed.
Yes. And Mr. Parvathaneni, can we talk a little bit about the visa categories? Can you give an overview about what are the different kinds of visa categories are available for filing an employment-based petition? And also, does the choice of choosing the visa category affect the processing time or the process?
Sure. So again, there are two classes. One, permanent employment, which is the green card. Permanent employment is done through the green card process. And then temporary employment. Somebody just wants to go and work right away. And for temporary, we'll talk about the temporary visas first. So temporary visas, the most famous ones that Indians use are H1B, the most popular. L1 probably the next most popular. And then there are other employment visas which are also used by many people. And one of it is the O visa. O visa is if they have some extraordinary skills, they have great achievements, they use O visa. And there are some people who are artists or sports people, athletes. They have something called a P visa. If they have to come and play or participate in an event, they can do it through a P visa. And there are also some visas available for some other countries. It's not available for India. There is something called TN visa. So people from Canada or Mexico can come easily on that visa and work. And there is also a visa called E3 for Australian citizens. People in Australia can use it if they're citizens. We also see some Indians who went to Canada, became Canadian citizens, or some Indians who went to Australia and who became Australian citizens. A lot of times they are also able to take advantage of E3 visa or the TN visas. And again, if it's the temporary non-immigrant visas, H1 is mostly used for people who have a bachelor's degree. Somebody who has a good college education in India, they have an engineering degree or a B pharmacy degree. Somebody who has a bachelor's degree, they typically go the H1B route. And L1 is used by people who are already working in the multinational companies working in India. For example, TCS, Cognizant, Microsoft India, or IBM India. If somebody is already working in that company and they want to transfer to the US onshore office, L1 is a very attractive visa, and a lot of people use that L1 visa. All they're doing is they're transferring from their India office to their US office. So that's on the non-immigrant side. And on the immigrant, which is the green card, the permanent employment, so that side, there are 5 categories: EB1, EB2, EB3, EB4, and EB5. So EB2, EB3 green cards, these are used by most of the Indians. So EB2 is if somebody has a master's degree. EB3 is if somebody just has a bachelor's degree. So that is the difference between EB2 and EB3. EB1, on the other hand, it's for extraordinary ability. Somebody has a PhD and has a lot of publications, or somebody has a lot of patents, or somebody is in a very high-level position in US. So EB1 is used for people with extraordinary ability. And also sometimes where for some big multinational companies, if they're transferring their managers from India office or foreign offices to US office. So it's EB1 is a very good choice for those kind of folks. EB4 is used by religious workers. So a lot of priests or pastors in India, or the Hindu temple priests. So a lot of those religious leaders who want to come here to US and work as priests or pastors, they typically use EB4. EB5, it is mostly for people who are investing. So if people have money to invest in US, EB5 is a good option. It's an investor green card. The reason it is lumped under employment-based immigration is because that investment has to generate jobs in US. So EB5, which is an investor green card visa, this is also getting very popular nowadays. So these are pretty much the high-level classes that most of the Indians use for coming to US, for working in US.
Yes. So, Mr. Parvathaneni, let's talk about priority dates. So, what is the concept of priority dates when it comes to these kind of employment-based petitions? And also, are there any strategies for expediting the process of filing for these kind of petitions?
So, priority dates, it's a common word that comes when people are talking about green cards. So for everybody that's going through the employment-based immigration category and applying for a green card to work permanently in the United States, there is something called a priority date. So priority date is nothing but it's the date that somebody is put in the green card queue. And there is a reason why there is a need for a queue. The reason for the queue is we do not have unlimited green cards. There is a limit on the number of green cards that US can issue every year. For the employment-based green cards, it is 140,000 green cards for the entire year. So 140,000 green cards is what, in general, United States can give in a year in employment-based categories. And out of that 140,000, they are divided between EB1, EB2, EB3, EB4, and EB5 categories. So in the entire 5 categories, we have 140,000 green cards. However, there is a catch. Indians cannot get all the green cards. There is an upper limit on the number of green cards Indians can get in general. So the general rule is Indians or any other country, there is a 7% limit on the number of green cards that can be given within this 140,000 green cards. So what that means is, because we have more Indians applying than what is available out there, everybody gets put in a queue. So the day they get that priority date, typically it's the day their labor is filed for most of the people, the day their labor application is filed. For some people, it is the day their I-140 is filed. So that is the day they get put in a queue. And what US does is, they go through the queue. They start off from somebody who has the oldest priority date, and they start issuing green cards based on that date if they qualify. So priority date is extremely important. It is the day they're put in the queue, and if there are people in front of the queue, the general rule is they have to be given green cards before their turn comes. So that is the idea of priority dates. And to speed up the process, what people should do is they should get into that queue as quickly as possible. And what that means is they need to find an employer who will sponsor their green card as quickly as possible. Because sooner the green card processing starts, the employer has to start for most of the cases, they get assigned a priority date if certain things are accomplished. So the way to prioritize their entire green card process is to get into this process as quickly as possible, as quickly as possible to meet the regulatory burden. So people whoever have started the green card processing early on, if they had their company sponsor their green card petition, their immigrant petition, the I-140, for example, the sooner it is done, the sooner they're in the queue and the sooner they can get out of the queue. So if somebody, and right now what is happening is somebody who got into this queue in 2012. So in 2012, for example, somebody in EB2 or EB3 category, if their company started the green card processing in 2012 for Indian nationals, those people are now getting their green cards after almost 10, 11 years. So if somebody who starts their green card processing in 2023, just this month, for example, they can expect to have a long wait, because right now, in the current month, this month of November 2023, we are seeing people in 2012, if they are from India, country of birth is India, those people are now getting the green card after such a long time. So priority dates are important because the sooner they get into it, the sooner the green card will be issued based on other regulatory rules that are in picture.
Yes. Let's talk about the employer's responsibility, Mr. Parvathaneni. So what kind of support can the employer give to the person who is, when their employee is filing for the H-1B petition? And also, what are the responsibilities that the employer must follow in the employment-based immigration petitions?
So employer has a lot of responsibilities, and this is very important. So the way the process works is the employer is making some attestations and petitioning with the US government agency for a benefit. And in this case, the benefit is they want some foreign-born employee to come and work for their company. And as a part of this process, they're filing this petition. And as a part of that petition, they're making a lot of attestations. For example, so-and-so employee is going to work in so-and-so role. They will be paid so-and-so salary. And so many things, the work location, the job duties, the salary that they're supposed to pay, and so on. And these are attestations that the employer is making to the government officials. And what this means is, it is very important. If there is a lie on the petition, it is perjury. It is a criminal offense. So the employer has a very big responsibility to make sure that they go through the petition that is being filed with USCIS, look at all the statements that are being made, and tomorrow make sure those are all honored. If a company files a H-1B petition, and tomorrow they tell USCIS that they're going to pay $100,000 per year to that employee, and down the line they don't pay that salary to the employee, they're not complying with the H-1B petition, they have a problem. So the goal is, the responsibility of the employer is go through every statement that is made in the petition that is being filed with the US government agency and ensure 100% compliance with those statements. If they lie, it's perjury. So which is very, very important. Overall, that's the responsibility, making sure they follow everything that they are promising USCIS. One part. The other part is they also have to ensure whatever they promise the employee. For example, they made the employee an offer, and tomorrow if the employee works under those terms, the employer has a big responsibility towards the employee that the salary, the required salary, is paid to the employee. So overall, it's a very important process, and everybody involved, the employer should ensure that they are following to the terms of their visa conditions. Employer is doing what they're supposed to do, and depending on the kind of a visa, depending on what is involved, sometimes site visits also happen. For example, H1B, they have a process where site visits happen. So employer should be prepared for site visits. There are requirements on how long they have to preserve certain documents, what needs to be done, and so on. They have certain requirements for some class of visas. They have to maintain certain files, some payroll records, and so on. So everybody has to be aware of what needs to be documented, what needs to be preserved, and it is the employer's responsibility to ensure 100% compliance with every filing they do with USCIS.
Yes. Let's talk a little bit about the request for evidences. So under what circumstances can the USCIS ask for an RFE? Is that because something has been wrong for the, during the, petition process? Or is it just like a general regular process that usually happens, Mr. Parvathaneni?
So as a part of this process, so any employer, before they get somebody to work for them, most of the time, it starts off with filing a petition with USCIS. Majority of the cases, there are some exceptions where, for example, like an E3 or a TN, where a petition is not required. But for majority of the cases, it always starts off with filing a petition with USCIS. And two things happen once a petition is filed. In general, either USCIS is happy with the petition, they approve the case, then everything is done. The case is approved, they're good. There is another thing that could happen. USCIS looks at the filing, looks at the evidence, and sometimes they're not satisfied, and they have questions. And when that happens, what they do is the process calls for issuing a request for evidence. So a request for evidence or an RFE, it is basically just a notice. It's a notice where USCIS sends to the employer, and they say, we see these and these issues, and can you please explain or please provide more documents to explain this issue. So that is what an RFE typically means. And for example, in the context of, say, H1B, some employer applies for a H1B, they petition for a H1B, they submit everything, they submit all the documents, and say that employee, he submitted his mark sheets, his degree and mark sheets. Sometimes USCIS comes back and says, this employee has a foreign degree. We don't know if the degree is valid. We want an evaluation from a reputed credentials agency, for example. Some person might get it, some person might not get it. But if USCIS raises that request for more evidence, they will tell you. They will tell us what needs to be done, for example. Now the employer has to answer back with clarification of those issues raised. Or sometimes the question could be, we don't know if you can pay the employee. Can you show us how you're able to pay the employee, for example? That is the question. Employer will say, okay, I have my tax returns, look at my tax returns, look at my invoices, or so on. So a request for evidence generally means USCIS is not satisfied, and they're asking for more information before they want to approve the case. Requests for evidences are not uncommon. And if somebody gets a request for evidence, it does not mean anything. All that means is somebody has to provide that required information to USCIS within a certain time limit. For most of the cases, typically, at least for H1B, they give 87 days, almost 3 months. So USCIS does give enough time because they understand that somebody has to gather those documents, prepare their evidences, and send it back to them. So for majority of the cases, USCIS gives enough time. USCIS also tells them what exactly they're looking for, gives them an opportunity to provide that evidence, and then eventually will approve the case. So majority of the cases, even if they get an RFE, majority do get approved because people are able to provide those documents for most of the cases.
Mr. Parvathaneni, it was a very, informative episode today, and I'm sure the viewers might have enjoyed like I have enjoyed. Thank you again, Parvathaneni Garu, for tuning in. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you so much.